Namaste friends, welcome back to Kaydanivato. Today we will discuss chapter 15 of the Bhartiya Nagrik Suraksha Sanhita 2023, explaining that when courts can take cognizance of the offences. This chapter covers section 210 to 222. BNSS chapter 15 titled Condition Requisite for Initiation of the Proceeding. Section 210 Cognizance of the offences by magistrate. A magistrate may take cognizance of an offence on a complaint, on a police report, on other information or his own knowledge, especially safeguard exist in the cases involving public servant. So section 210 is explained that when the court take cognizance and when the magistrate can take cognizance. Section 211 transfer and application of the accused. If cognizance was taken based on own knowledge or other information, the accused can apply for transfer to another magistrate. Section 212 making over of cases of the magistrate. The chief judicial magistrate or chief metropolitan magistrate may assign cases to competent magistrate. Section 213 cognizance of offence by court of session. A court of session cannot take cognizance directly, it can only try the cases committed to it by a magistrate. Section 214 additional sessions judge. An additional session judge can only try the cases made over to him by the sessions judge. Section 215 prosecution for contempt of authority, offence against the public justice and documents related offences. For offences like contempt of lawful authority, perjury or evidence tampering, cognizance can be taken only a written complaint by the concerned public servant of the court, not just on a police report. Section 216 witnesses intimidation cases. If a witness is threatened or pressurized, the witnesses or any person can lodge a complaint regarding the such offences. Section 216 says that witnesses intimidation cases, if a witness is threatened or pressurized, the witness or any person can file a complaint regarding the such offences. Section 217 prosecution for offences against the state and conspiracy. For certain offences against the state or conspiracy to commit them, prior sanction of the government or district magistrate is required. Section 218 prosecution of the judges and public servant. If offences are alleged against the judge, magistrate or certain public servant for acts done in discharge of official duties, cognizance required prior government sanction. Section 219 offences against marriage. For specific marriage related offences, cognizance can be taken only on the complaint of the aggrieved person or certain close relatives with the court's permission. Section 220 prosecution under BNS section 85 cruelty by the husband or relatives. Cognizance requires a police report or a complaint by the aggrieved woman or close relatives. Other can complain with the court leave. Section 221 cognizance of the offence under BNS section 67. When parties are in a marital relationship, the court can take cognizance of an offence under the section 67 only upon a complaint made by the wife against the husband. Section 222 prosecution for defamation. For criminal defamation under section 356, cognizance can only be taken on a complaint by the aggrieved person. So friends, in this chapter ensure that criminal proceeding begin with the proper safeguards, especially in a sensitive cases like those involving public servant, state offences, marriage related offences and defamation. This protects both the rights of the citizen and the fairness of the criminal justice system. So friends, if you found this breakdown is useful, then do like, share and subscribe this channel Kaydanivato. We will meet soon in next video with new chapter. Till then, bye. Take care. Jai Hind. Stay connected with Kaydanivato.